I'm pleased to say that Professor Karis Craig, our very own from Osgoode Hall Law School, will be kicking off the third panel, delving into the more specific aspects of UGC. So, Professor Craig.
I haven't done anything yet. Thanks, everyone. I hope you're enjoying your day. It's been a wonderful morning, and we're going to keep the pace up this afternoon, turning our attention to specific aspects, legal aspects of user-generated content and, of course, the new UGC exceptions. So to begin, we're going to have a presentation by Eva Subotnik, who is an assistant professor of law at St. John's University School of Law, where she teaches courses in the intellectual property field. She's also been an intellectual property fellow at Columbia Law School. She'll be speaking to us about appropriation art. Following Eva, we're going to hear from Marion Hebb, who will be speaking to us about UGC and the very interesting topic of fan fiction. Now, Marianne practices arts, entertainment, and copyright law at Hebb and Sheffer, but prior to practicing law, she worked for 10 years as a book and magazine editor. So I'm looking forward to the panel. I won't take up more of the time. I'm going to pass things over to you, Eva. Thank you very much.
Well, thank you so much, Karis, and thank you so much for inviting me to be part of this wonderful symposium, including, I'm happy to see, the sharing of our school colors, which makes me feel so welcome. So my charge today, as I understand it, is to give a brief overview of the treatment, the legal treatment of appropriation art or collage under U.S. law. Can you hear me, or should I speak closer to the mic? Yeah? So let me start by laying out the legal framework governing such artistic practices, highlighting first the constraints on, and then the opportunities to engage in these forms of creative endeavor. Along the way, I'll also address some of the thorniest issues that continue to challenge both artists and the courts. So beginning at the beginning, the U.S. Constitution authorizes Congress, that is when it's not shut down, to promote the progress of science and useful arts. And that it's attempted to do by creating a system of copyright laws. Accordingly, when a creator engages in appropriation art or collage that's comprised of underlying copyrighted materials, she operates under the shadow of a copyright holder's exclusive rights, within certain limitations, which I'll describe, to control the reproduction, adaptation, distribution, public performance, and public display of her copyrighted works. Such a creator also operates against the backdrop of pretty stiff remedies, including both injunctive and monetary relief, if she were to be held liable for violating one or more of these rights. In particular, statutory damages from $750 to $30,000 per infringed work. However, if the copyright holder can prove that a defendant artist has willfully infringed a copyrighted work, which may be a successful argument if the artist is on record somewhere expressing her interest in incorporating copyrighted works into her own work, then the defendant artist runs the risk of a discretionary enhancement of statutory damages up to $150,000. On the other hand, if the defendant can prove innocent infringement, the court is permitted to reduce the statutory damage award to $200. Okay, so now that I've sketched out the risks inherent in engaging in these sorts of artistic practices in the U.S., which may constrain the degree to which they are undertaken, under what legal authority have appropriation and collage artists nevertheless claimed rights to pursue these modes of expression? The most important shield against liability, as we've already heard, is the Fair Use Doctrine, which exists as a limitation on the reach of a copyright and is applied on a case-by-case basis. U.S. Fair Use Doctrine permits certain uses of copyrighted works for purposes such as criticism, commentary, and scholarship, and requires consideration of the following four factors: the purpose and character of the use, including whether it's of a commercial nature or is for nonprofit educational purposes; The nature of the copyrighted work. Is it factual? Is it fictional? Is it published? Is it unpublished? The amount and substantiality of the portion used in relation to the copyrighted work as a whole, such as how much was used, was it the heart of the underlying work, and the effect of the use on the potential market for or value of the copyrighted work. That is, does the use interfere with the copyright owner's licensing market for the original or derivative uses? Under the first factor, the purpose and character of the use, courts typically consider the degree to which the use, and in our context, the new work or collage, is transformative. As defined by our Supreme Court, the term entails inquiry into whether the new work merely supersedes the objects of the original creation, or instead adds something new with a further purpose or different character, altering the first with new expression, meaning, or message. This term, transformative, has proven extremely capacious, permitting not only works, uses that physically transform the underlying work, but also those that keep the underlying work intact but recontextualize it to communicate a distinct message. But this should not be taken to mean that any reworking of an earlier work to create a new message will be deemed fair. Courts will continue to balance all of the factors, including how much and which parts of the underlying work were taken, and whether the new work supplants the rightful market of the earlier work. So in line with the focus of this symposium as to user-generated content, I'll next discuss a few key cases by which to illustrate some of the guidance available for creators working in this area. Not surprisingly, a number of our prominent cases relate to suits against deep-pocketed, well-established defendants, as we've already heard a little bit about this morning, and we'll hear more about now. In many ways, it's lawsuits against such highly visible artists that supply the law for everyone else, which is why I've been so interested to learn more about your new user-generated content statute, which we do not have one of in the United States. Of course, the appropriation art tradition has been around for a while in the United States. In broad brush, pop art star Andy Warhol's work has been labeled in that way. Sherry Levine's work, which included the rephotographing of early photographs, is also put in that camp. But without question, the primary source for contemporary law in this area is a string of cases lodged against Jeff Koons for works that he made first in the late 1980s, and then more recently, a case challenging a work that he made in the 2000s. So the earlier litigation related to a series of sculptural works that Koons produced for the Banality Show in New York, in which he incorporated images of mass culture into new works in order to comment critically on the incorporated object and the political and economic system that created it. The exhibition gave rise to several lawsuits, including with Koons' sculptures on the right, and here I'll be displaying the images in Gordon's preferred fashion in equal sizing. There is this lawsuit, and this lawsuit, and finally this lawsuit. The last one, Rogers versus Koons, was the most important since it produced an appeals court opinion. The court sided with the plaintiff photographer, holding that Koons' string of puppies sculptures over there were infringing and were not saved by fair use. There were at least two aspects of this decision that did not augur well for the future of appropriation art. First, the court stated that in order to successfully come within the fold of fair use, the new work had to comment on or parody the underlying work itself. A new work that used the underlying work merely to express general social commentary would fail to justify its copying. Second, the court suggested something of an authorial competition in the case, pitting the plaintiff, who had steadily built a professional photography career and whose first name miraculously was Art, that is to say Art Rogers, pitted him against the self-promoting former commodities futures broker turned modern Michelangelo Koons, who didn't even create his own sculptures but outsourced that manual work to Italian artisans. The import of this case and of those two aspects that I just mentioned has, however, been diminished by later cases, including another one against Jeff Koons called Blanche versus Koons, in which Koons was sued by another photographer over the use of her photograph to create this painting called Niagara for a Deutsche Bank Guggenheim Foundation sponsored exhibition, for which Koons was paid approximately $125,000. The same court that had decided the Rogers case, the String of Puppies case, decided this time in Koons's favor. The court relented somewhat on the notion that the use of a copyrighted work had to be driven by the need to comment on that particular work, accepting this time as a justification the targeting of the genre of the slick fashion photo, of which the plaintiff's photo, over there on the left, was typical. Further, as to the status of each creator, the court appeared to put both Blanche and Koons on an equal footing, acknowledging the creative bona fides of both. Perhaps most notable from the opinion was the court's heavy reliance on statements by Koons in his affidavit, in which he said, among other things, although the legs in the Allure magazine photograph might seem prosaic, I consider them to be necessary for inclusion in my painting, rather than legs I might have photographed myself. By using a fragment of the Allure photograph in my painting, I thus comment on the culture and attitudes promoted and embodied in Allure magazine. By using an existing image, I also ensure a certain authenticity or veracity that enhances my commentary. Now, among commentators, the Blanche case was either a cause for hope or a cause for concern for artists working in appropriation art or collage media. On the one hand, the court in Blanche broadened fair use doctrine to accompany uses of an underlying work to produce social commentary that was more loosely rather than more directly aimed at the underlying work itself. On the other hand, from a critical perspective, the court's reasoning seemed to contradict postmodern sensibilities in that it prioritized the defendant's own explanation of his work above other possible interpretations. Furthermore, from a utilitarian perspective, the decision threatened to deter uses by less well-heeled artists who failed to mount such articulate explanations of their uses. The import of this failure to articulate came to a head in a recent case that we heard a little bit about this morning, the Carew versus Prince litigation, in which the defendant, Richard Prince, used approximately 40 of Carew's photographs to create 30 large-scale collages. Although not apparently for lack of funds to hire counsel, the defendant, Richard Prince, did not appear to help himself at his deposition. In response to questions such as, and here I'm paraphrasing, were you commenting, so this is Prince's work and Carew's work, the underlying photograph. Were you commenting on these photos? Were you commenting on the photographer's technique or methodology? Were you commenting on any aspects of culture? Were you trying to create anything with a new meaning or message? The answer was no, 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 and no. And those responses were really the end of it for the lower court, no fair use. And the court also ordered the collages to be rounded up and subject to possible destruction at the determination of the plaintiff. But the appeals court, the same one that had decided the Rogers and Blanche cases against Koons, held to the contrary. And the appeals court said, what is critical is how the work in question appears to the reasonable observer, not simply what an artist might say about a particular piece or body of work. Prince's work could be transformative, the court said, even without commenting on Carew's work or on culture, and even without Prince's stated intention to do so. So while this reasoning might seem to put to bed concerns that I mentioned earlier, namely that a defendant artist might not be willing or able to articulate what makes his work transformative, The court has opened another window of uncertainty for artists, namely how to judge ex ante what a court might later say about one's work. Consider that the court found 25 of Prince's work to pass the test of fair use, but remanded 5 works for further consideration. So this is not a clear victory, an entire victory for Richard Prince. The court could say that Back to the Garden was a fair use, but, quote unquote, we cannot say with certainty whether Graduation, this work, or another work, Charlie Company, presented new expression, meaning, or message. Now, it would be wrong for you to draw the conclusion from what I've said that litigation only lurks for deep-pocketed defendants. Mattel, the copyright holder in the Barbie doll, sued Thomas Forsythe, a self-taught photographer, quote unquote, over his food chain Barbie series, in which Barbie is photographed as subjected to destruction by an untold number of kitchen appliances, all in the service of a critique of the objectification of women associated with Barbie. All told, Forsythe had yielded only about $3,700 from his series, but he was nevertheless forced to defend a lawsuit he ultimately won and actually was awarded approximately $1.6 million in attorney's fees for it. But anyway, really in conclusion, what guidelines can I offer for safely proceeding with a work of appropriation art or user-generated content in the US? As you can see from what I've said already, a lot of the case law that's out there really has to do with physical works and not works that are produced or live online. So that's kind of an overlap that remains to be sorted out, or a disconnect even. While it may or may not be helpful in particular judicial circuits within the US, in most cases, it certainly behooves the user, where possible, and where the user is willing to have an articulable reason as to how and why, from an artistic or communicative point of view, the use of a copyrighted work facilitates the creation of a new work with a new meaning. Attribution is also helpful. And in addition, one would of course be wise to use the least amount possible from the underlying work in order to convey the new meaning. These views, this little bit of guidance that I've just given, cohere with a set of principles that have been developed at American University to facilitate user-generated video that comes within the fold of fair use. I'm not, however, aware of any litigation in which a defendant's reliance on these guidelines has been tested, but these principles are available to you online. I have a few more thoughts that I could bring to bear, but I think I'll wait for the Q&A part, so thank you very much.
I'm not using that. Okay. Is this on? The wording of the new UGC provision certainly legitimizes and legalizes not-for-profit fan fiction, sometimes called fanfic or fandom, and perhaps even fanfic flicks, from which all profits go to worthy causes, might be covered. Section 29.21 will allow anyone whose use of the new work is non-commercial to take a shortcut and incorporate substantial parts of a story written by someone else into a new work, borrowing and building on characters, settings, and plots. This is what fan fiction today is. Very prevalent on the internet, and fanfic sites are often supported by advertising. If you haven't already visited, do visit fanfiction.net, and there are many other sites. Harry Potter, fanfiction.com, it gets more than 50 million hits a month. Archive of Our Own is run by an organization for transformative works in the US, which takes the position that fan fiction is fair use. but it requires an application to fully access all its features. I'm wondering whether there's some reason for that there, in case there's some, to be able to say that it's not available to the public in the same way, because attendance is, or accessing it is by way of invitation. There are many sites. I didn't find one just now at lunchtime for our first Canadian Nobel Prize winner for literature, Alice Munro, but who would dare to attempt to write fan fiction as a sequel to a story by Alice Munro? Well, actually, that's probably a silly comment, because people don't hesitate to write fan fiction about anything. Some of these sites, maybe all of them, will remove the content, or most of them will remove the content if there's a complaint from an author who does not wish fans to actively engage with his or her work through posting of derivative stories. There are a number of flaws in the drafting that's been alluded to earlier this morning. I'm not going to say any of the things I was going to say about non-commercial purpose, except to comment that I have lots of clients, authors who have written books which are for non-commercial purposes. That's perhaps broader than the situation where the author doesn't get any money at all from it, but there are lots of those situations too in different circumstances. I have a question, which is it possible under this section for a film based on a book to be made without permission from the author, solely for non-commercial purposes? Any proceeds perhaps going to a worthy charity? It could be shown first, a film could be shown first in a theater or movie house. A theater is probably what's the wording in the statute, is probably a entity that regularly provides space or means for works or other subject matter to be enjoyed by the public. The second window would be dissemination on YouTube. This and other examples would go far beyond the examples given by the government in their policy backgrounder, which referred to this section as being the examples include making a home video of a friend or family member dancing to a popular song and posting it online, or creating a mashup of video clips. This section is far broader than anything like that. I think that was a little misleading. What's wrong with this picture? I'm referring to section 2921 in force now. Well, what I think is wrong is that the author of the new work is free to use the new work, presumably sending it to anyone, and authorizing an intermediary to disseminate it on the internet on a site such as YouTube, where millions can access it, while the author of the original work doesn't get paid anything. Maybe the film goes viral on the film, if I'm right about that. I think I am. A video certainly could be circulated like that. Maybe the film goes viral on the internet and causes the first author to lose a film deal or the opportunity to sell film rights. Posting a UGC work calls attention to the original work. Could be positive, could be negative. One well-intentioned, but I think probably ineffective, safeguard in this new section is the condition that the work should not have a substantial adverse effect on the existing work, but you don't know that until afterwards, after the harm has occurred and the original market for the original work might have been damaged or destroyed. There is some rivalous competition perhaps with the sequel. Maybe somebody writes a sequel which is better than the original author. Well, you may say, so be it, but anyway, it is the original author's creation. There could be confusion as to the authorship of derivative works, and the original author's reputation would be more likely tarnished than enhanced. Few professional authors will want to sue their fans, even if they have grounds to do so. Imitation and even parody are supposed to be a form of flattery, or so they say. Now, with our new UGC provision, there's little danger that a fan who sticks to the rules, albeit the rules are not all that clear, will be sued for copyright infringement. But is there a danger of the fan suing the original author for copyright infringement of a sequel written by the fan? I wonder whether to prevent litigation of this sort, whether we should consider whether or not the author of the existing work should be deemed in some way to be the author of the sequel or the owner of the copyright of the sequel owned by the fan. These are all what ifs, and my movie example may seem to be a stretch because of budgets required for professional productions, but an artistically talented Belinda Stronach could probably do it. Without commercial purpose, and there are lots of low-cost, high videos available on the internet. Ask John Deegan in the back row there, executive director of the Writers' Union, about that, but his videos, his works are never derivative. I'm not against a UGC provision, but I think it badly needs revision. Perhaps the right to authorize dissemination, as well as being for non-commercial purposes, should be only for the individual's private purposes, as is the case for the reproduction of works and other subject matter under Section 29.22. There'll be lots of disagreement and I'm sure litigation about that. Our notion of privacy today is really being stretched. And can you share a work with sort of hundreds of Facebook friends? Is it still private? Sharing fan fiction with millions on YouTube would not be private. Were that phrase to be added to 29.21 as well. It is my view that a new work that uses an existing work by another author should remain private unless there is payment, or in some instances, permission as well as payment. Prior to the coming into force of the copyright amendments last fall, an author had the exclusive right to authorize adaptations of his or her work, and that's no longer true because of 29.21. J.K. Rowling doesn't mind fans writing stories about Harry Potter, but J.D. Salinger did mind another person writing about Holden Caulfield. In Canada, writers who, like Salinger, don't want authors to create stories for their characters can no longer prevent fans from doing so if they're available for non-commercial purposes. Clearer restrictions and other refinements are needed to make the exception for unauthorized user-generated content fair to the original author, whose works could be distorted and whose opportunities could be damaged or even scooped by another author. These issues do not disappear just because the creator of the new work has no commercial intention. Now, coming back to Salinger for a minute, the author sued by Salinger for writing a sequel about Holden Caulfield in his old age was not using Salinger's character from Catcher in the Rye for non-commercial purposes. And therefore, it wouldn't have helped if the U.S. had had a section like our UGC exception in the U.S. Act. The trial court, an injunction proceeding, rejected the fair use argument that Colting's book was a parody and found it to be an unauthorized derivative work. The decision to grant an injunction was appealed, but the parties settled on a confidential basis, which included an agreement not to publish the work in the United States. You can buy it on Amazon.ca if you're interested, and similar litigation would presumably have had a similar outcome in Canada. The sequel clearly served no commercial purpose, but if there had been no settlement agreement allowing publication in Canada, and if Colting's contract with a publisher in Canada had directed all the royalties to be paid to the Writers' Trust of Canada, or perhaps to the Student Society here at Osgoode Hall, would Section 29.21 now allow him to publish in Canada without the permission of Salinger's estate? Maybe Colting's right to do so was contaminated by his original purpose in writing the book, which was first published, self-published in Sweden. So my question is, can anyone write and authorize for dissemination in Canada a sequel of anyone else's novel without authorization from the author if the sequel's author is without commercial purpose? And if so, should that really be the law? I don't know why Salinger didn't want to license his book, which had already been published in the United Kingdom, called Colting's book, where it was described as a sequel to Catcher in the Rye. Colting speculated later, rather arrogantly, that Salinger hadn't read it, or he would have been pressed and would not have sued. We can only guess it was more likely that Salinger didn't want anyone to mess around with his own creation. And that's surely legitimate and a view commonly held by many authors. Moral rights with respect to literary works don't cut much ice in the US and didn't figure in the Salinger case. Well, I'll skip over what I was going to say about moral rights, except to mention that there is a zombie parody of Pride and Prejudice written by a best-selling American author. And Jane Austen is given a co-author credit for the book. and the publisher, or perhaps it was Amazon, wrote this on their website: an expanded edition of the beloved Jane Austen novel featuring all new scenes of bone-crunching zombie mayhem, and ends by saying, Pride and Prejudice and Zombies transforms a masterpiece of world literature into something you'd actually want to read. I had a client who, I was presented with a zombie version of a book by an author that I represented, and my clients actually gave me instructions to not to give them permission. I hope that author and that publisher don't know about this new section, because they probably could publish now if the author is rich enough not to need the royalties, and if she could divert her royalties to the Charitable Society for the Protection of the Walking Dead. I'm going to skip over quite a lot of what I was going to say, but I think that my main objection to this section is that it doesn't help professional authors. I think that's its biggest flaw. I think consideration should be given to refinements that could help authors with commercial intent. For example, authors of tribute poetry. This sometimes leads to disputes where the first poet may not be reluctant to accept the advice that his lines quoted in another poet's poem should not, for instance, be treated as an infringement. Poets don't expect to make money, or a lot of them don't. Some do, few do. But it would not be credible to argue that a published book, it was solely for non-commercial purposes in order to benefit from the section. The late P.K. Page, a very distinguished Canadian BC poet, wrote a poetry book called Coal and Roses. And each poem she borrowed, this is her words, a quatrain from another poet, each line of which was repeated in one of her own stanzas. They're beautiful poems. And this is a form which was popular in the 14th and 15th century among poets attached to the Spanish court. It's a really wonderful example of what we crudely or legalistically call UGC. There's really nothing new about UGC except in the manner of its dissemination and the rules that have to be followed. The damage from quoting a few lines of poetry in another poem where there's attribution to the original poet is likely to be de minimis. David Baver was talking this morning about trivialities, and I think that's a good example. But I think a more carefully crafted UGC provision could deal with this and be useful to professionals as well as to fans, just as it could have dealt with parody, which relies on substantial similarity to the work being parodied, and when the author has a commercial intent, as an alternative to the new fair dealing extension in 29 for parody and satire. If UGC remains private, I don't think anyone should complain. If it goes public, there should be payment, and sometimes both permission and payment. Then the UGC provision could be useful to professionals as well as the fans. This past May, Kindle launched a service called Kindle Worlds, which licensed popular books, television shows, et cetera, in order to allow writers of fan fiction to publish and sell their works, their stories based on these works. I also have one other question, which is there a role here for collective management and licensing so that the UGC provision might include uses by individuals who do have commercial purposes? A collective could collect and distribute minuscule payments from the likes of YouTube and direct queries to individual rights holders when permissions must be obtained in instances which might not be covered by a revised wording of 2921. The biggest question is whether there will be any will to repair or fine-tune this 2921. The biggest question is, at the time of the mandated review of the Copyright Act in 5 years' time. I'll stop there and in closing say to any of you who may be thickers, I hope you agree with at least some of what I've said.
Okay, thank you to both of you. So I'm going to open the floor up now to questions. If you have a question, please make your way down to one of the microphones.
I have a quick question. I'm Joy Muller, Associate Director of Libraries at Seneca College. You mentioned the Kindle World, but there's a piece of information left out there. Are they compensating the original authors for the fan fiction? Yeah, they are.
Yes, they're paying a royalty.
Okay, thank you.
And they, actually, I don't remember if it's that site. I think that may be the site where they have, if it isn't theirs, it's another one, where the site itself have got permission from a number of authors and a number of big film companies, media companies, et cetera, and they are inviting people to write specifically about those books and so on, and so they have an overall blanket permission.
Thank you.
It should be just lean closer.
Hello?
Yeah.
Okay. My question is for Professor Subotnick. I wanted to ask you about the Kiriou and Prince case with regards to the reasonable observer test. So to me, this is very interesting because it's importing a tortious test into the art world, right? I mean, when you think of art, you think of self-expression and its subjectiveness. So I want to ask if the courts have really threshed out that test. Have there been other cases? Because it's interesting to me, I'm kind of conflicted with that. On one hand, I think that it kind of destroys, when you talk about the reasonable objective observer, it destroys the concept of subjectivity in art. But on the other hand, I think to myself, well, this is a very good thing because, you know, with all respect to Mr. Dugan, I disagree with you when you talked about, you know, the psycho scene, the shower scene, and how it really wouldn't matter. You could have used any scene and slowed it down and it wouldn't have mattered. Everyone in the audience, as soon as they saw it, they automatically said, this is, you know, Alfred Hitchcock, this is Psycho, Year, and they recognized that scene right away. And as a result of that, you know, they had a positive impression in their mind. So I think if you had used John Smith or anyone else, it wouldn't have had the same effect. So I think, on one hand, I think, yes, objective is good to use an objective, reasonable observer test. On the other hand, I think it kind of destroys the subjective intent, which is art, right? So my question is, have the courts really threshed out that reasonable observer test?
Right, so it's a very nice question. The source of the reasonable observer test is actually a Supreme Court case involving parody, and that was kind of our well-known case about the song Pretty Woman being parodied in a version of the song, an adaptation, new work created by Two Live Crew, the rap group, in the 1990s. And the language of reasonableness came from the court talking about parody and saying essentially that whether a new work is a parody is one that a reasonable observer could determine. So the parodic character of the new work is one for a reasonable observer to determine. But what's been somewhat controversial is the transposition of that language into new and different contexts. So you're quite right that perhaps there, which was, you know, a specific arena, you know, a specific context, does it make sense to import that to the question of what kind of overall one makes of a secondary work, a derivative work, an adaptation? And I think that the thing that's troubling is that there seems to be absolutely no sense of what a lower court would do on remand with these cases, with these works that the appeals court found not to measure up as a matter of law as a fair use. And so, you know, who is the reasonable observer? It seems almost as if in the appeals court opinion in the Kiriou versus Prince case that it was simply the court deciding that we reasonably take this to be transformative and a fair use. But, you know, there have been other cases in other jurisdictions where courts have avoided, for example, using survey-based evidence as to what one makes of a secondary work. So it's really, I think it's unclear whether or not this is a good or bad development until there are more cases, which means more litigation. but it's very, I think the import is yet to be determined.
Thank you.
Thank you for a very interesting and very, very informative presentation. My first question, in the United States, would you reach the same conclusion, just generally, given all the counter limitations that are in 2921, is there that much of a difference where, at the end of the analysis, you wouldn't come out more or less in the same position with fair dealing? And I also have a question for Ms. Hebb, but I'll take your question first, answer first.
Well, I'm not going to let myself be pinned down to illegal analysis because I've been incredibly educated by this symposium, and so today is actually my first real engagement with the statute, so I can't comment. It obviously, aspects of non-commerciality. One of the things that's come up in U.S. Fair use case law is the extent to which a commercial use will or won't bar a fair use determination. And over time, the courts have, even from the Supreme Court down, become more liberal in saying, a commercial endeavor does not necessarily take one out of the realm of fair use. So I might see a disconnect there, just in terms of that very important discussion we were having about the Canadian law. I actually, if I could I ask you a question?
Sure.
Just in terms of finding the synergies, because we didn't really talk that much about provision C in 2921. The notion, a limitation, right? The individual had reasonable grounds to believe that the existing work or other subject matter or copy of it, as the case may be, was not infringing copyright. And Peter, you and I were having a conversation about what this means, but the question I have, what was driving this particular provision, and sort of what documentation does a user need to have to fulfill this requirement?
Well, the user doesn't have to know airtight.
Okay.
The user does not need any documentation.
Okay.
However, if the user knows or should know, based on whatever position they're in, that this was infringing, the least you're going to do if you're going to take advantage of this section is you're not going to use infringing work as your basic raw material. In other words, you're going to go to the art supply store and buy your paint, and then you're going to paint something that's very similar to what somebody else painted, but you're at least going to buy the paint.
But this gets to what the user reasonably knows about the underlying material, right? His source material. Not about his own use.
Right.
Fitting into this.
You have to read this. Some of the recent Supreme Court cases have said, since fair dealing is a user's right, you're going to use the perspective, the standpoint, the point of view of the user to make some of the determinations under fair dealing. The same methodology would apply here. You'd have to look at it from the point of view, here's a third grader who's an individual that's doing stuff. What's reasonable for a third grader to know? So you have to put yourself in the shoes of the user. And what this is saying is, if you know that this is not infringing, and by the way, breaking a technological protection measure is not infringing, because that's not infringement of copyright, that's something else, then you're out of this. Then you're out of this section. It's a good question. What I wanted to ask Ms. Hebb was, thank you for clarifying that Kindle situation, because that would have been troubling if that indeed was not reimbursed. I'm glad you clarified that. But in Section D, you're painting this with an exceptionally broad brush, I think, and what I'm hoping you can do is, what in your mind is the meaning of the words in the second line of D, or otherwise, and also on the third line, the word potential?
The word in the third
Because
line?
if the words or otherwise, and if the word potential were not in there, then I think some of these scenarios that you talked about being concerned about would be better founded. But if I understand some of the examples that you gave, they would fall within or potential. So what do you think those words mean?
Well, I think the word or otherwise, of adverse effect, could be mocking a work in such a way that people kind of write it off. And it's kind of people no longer respect the writing because of the fun that the fans make of it. That's a possibility. On the exploitation or the potential exploitation, are you suggesting that because you have potential exploitation, you don't have to wait until afterwards to find out if there's an adverse effect? Those are maybe a bit contradictory.
This language gives the plaintiff, gives the original owner who is opposing a 2921 claim a lot more latitude to defeat the claim than one would have taken from your presentation.
I'm not sure I understand your point about the potential. If you're suggesting taking out the potential?
No, I'm
Or you're
potential's in there. So
you're suggesting that undoes the necessity to
you just have to
look
demonstrate
after the fact and see whether in fact harm has been done?
in order to trigger the disqualifying clause, thereby, knocking out the 2921 defense. It doesn't matter if the exploitation is real or potentially real, because it says right here, or potential.
Okay.
And that broadens quite a bit, actually much more than I would like, but it broadens quite a bit the ability of the first owner to defeat a 2921 claim. That's a very powerful word, and Parliament put it there for a reason. And I think the reason was they were trying to really balance this legislation, and they were worried that without that word, maybe it would go too far in the other direction. So I think that they were being exceptionally cautious in making sure that this just applies to very, very specific types of situations.
Well, take the example of a sequel, for instance. How can you ever argue that a sequel written by somebody else can wreck your market because, in fact, you were going to write a sequel? You can't. That's obviously nonsense.
And as the job of the good lawyer is to make that argument, and it's there for you.
I think it's a pretty difficult one to make, and I look at our Supreme Court that seem to require actual adverse effect to be adverse, actual harm, actual damage to be proved. Hypotheticals don't seem to cut much ice with them.
Any other questions from the floor? Okay, I have a few minutes, so I'm going to exercise my chair's prerogative and ask a few questions, if that's okay. We caught up? Okay, so thank you both. Very interesting presentations. I think it strikes me that you're coming from slightly different directions in terms of what you think should be a lawful reuse of protected works. And so maybe my bigger question is just to ask you, maybe to engage in a bit of a conversation or response in terms of what you've heard from your fellow panelists. But I do want to break down the couple of questions as well. So for Eva, just in terms of the fair use provision and its application in recent case law, and especially this distinction between the weapon parody and the target parody that came out of the Akafor's decision, I'm wondering if you can tie that back to what we heard this morning and think a little bit about what Gordon was saying about the materials that he was using for his art essentially being like the paint, like the canvas, and really the expression is in the way that those materials are used. It's very much not a use that refers back then to the original in that sense, which makes it seem more original, but at the same time it makes it seem less likely to qualify as a fair use. And certainly the idea of the reasonable observer in there is very interesting to me as well. It's also a creep just from the substantiality analysis. Have they taken too much? So I'm interested as well in thinking about the overlap between assessing substantial taking and assessing transformative use. And I'm wondering if maybe more of that analytical work could be done at the stage of finding the prima facie infringement rather than pushing creative reusers into the realm of copyright defenses. So maybe I'll stop there and let you respond to that.
Yeah, sure. I think what's kind of fascinating about the Carreyrou versus Prince litigation is, just a number of facets, but that kind of there was an expressed intent by the defendant, Richard Prince, and it was very much creative. He was looking, he stumbled across the book And he thought that it was useful in, the kinds of projects he wanted to engage in, which were about, I'm paraphrasing here, but kind of making a movie, I think, or he obviously used it for a series of collages, but he was going to make a movie of some sort about kind of a post-apocalyptic world where, people interacted in certain ways and focusing on the importance of music and culture. And it was very much not in line with the kinds of statements that Koons had kind of worked himself up to. I mean, the trajectory of Koons, the Koons litigation would have suggested that at the very least, you need to have some articulable explanation for how you're commenting on culture, even if not the particular work, at least the genre. By contrast, the Prince as a defendant, he did have an interpretation of his own work, but it seemed very personal to him. It was about his own personal artistic projects. And what's fascinating is that, our appeals court bought that. I mean, it accepted it. It didn't push back. And to get back to your point about, what does this test of reasonableness do for us? I mean, I think what it does is it puts the court in the position of not having to decide, which narratives are acceptable in a certain kind of a way. The court actually gave its own sui generis kind of explanation of what it thought was going on with these works. But I think that we're sort of at an extreme. We've really been taken quite a bit far away from this original need to target the original, and that courts, if they follow the Second Circuit precedent, are likely to accept the goal broadly of this fit into my artistic vision. We'll see if that works. And again, I think it's really important to state that this was not a clean victory for the defendant. There are still 5 works, if they don't settle, there are 5 works that are still going to be litigated with the potential for substantial damage awards. So we'll see. But I think, that's sort of the trajectory in which we're going.
Mm-hmm. Thank you. Marion, sorry, just a quick one for you. And again, it's really a response to some of the conversations that we heard in the morning to try to bring these ideas together. I heard you talking about the original author wanting to control what's done with their characters in fan fiction, in sort of derivative uses of those characters. And it's often struck me that the way authors refer to their characters is almost as though they're their offspring in some sense, that they feel this personal attachment, that they want to be able to control what they go off and do when they leave home. And I wonder if we can tie that back to the idea that this is maybe futile or misunderstands the relationship between the author and the author's creation. That in a sense you can't control, just as a parent can't control what their offspring does when they leave home, the author can't really control what happens to their characters once they're out
Well,
there
I
in
guess
the
I would
world.
say that most authors actually don't mind it, or I think most authors don't mind it. Most authors will not want to necessarily pull back. They think it sells books, and it is a form of promotion. So I'm not sure that's true, but if I could actually just have one quick moment to reiterate one thing I said, which relates to what you were talking about, is we run a legal aid service in Toronto, a free legal aid service to authors. And one of the repeated questions that I kept getting when I was being duty counsel was people would come to you, a collage artist would come to you, and these are professional artists, and they're using baby bits and pieces from different paintings and sticking them together and so on. And once I think they can do the original without any trouble, but once they start wanting to make reproductions of what they've done, then maybe they're getting into trouble. If there's substantial bits from a particular, some image from Salvador Dali or something rather that's really, really distinctive, they're really getting into trouble. So I think it is really, really important for us, people that are interested in it, to try to make sure that this section is amended so in fact it can benefit professionals in some way. And that involves as well that in fact the authors whose works are used should, as a matter of principle, be paid.
Thank you. Okay, so I just have one final thing for Eva, which is to say, having watched copyright reform in Canada, we've seen in Canada some American provisions, for better or worse, being essentially picked up and parachuted into the Canadian legislation. And I'm wondering whether there's any appetite, now that you've been here and heard what you've heard today so far, to take 2921 and pick it up and parachute it into the US legislation to complement and to round out fair use.
Well, I can confirm that I do plan to go home to New York tomorrow, and I will be bringing a copy of this with me. I don't plan to parachute in, though. But no, this is fascinating, and I am teaching copyright law in the spring, and I look forward to talking with my students about this and thinking more about it, so thank you.
Thank you. Okay, thanks to our panelists, thanks to our audience for great questions. Thank you.